Let's see how smart you are. Write a data sharing contract that complies with California's, Colorado's, Connecticut's, Utah's, and Virginia's privacy laws. Ha! I knew it. Hello? Hey, Happy New Year. Happy New Year. We're still saying that? Sure we are. We still have our Christmas decorations up. Speaking of the new year, where do we stand on compliance with all these different privacy laws taking effect in the US this year? Getting a lot of questions from our advertising clients. Funny you should ask. I'm actually working on that as we speak, and I've consulted with some experts, and the feedback that I've gotten is that it would be quite difficult to create a data sharing contract that complies with all of the different privacy laws of California, Colorado, Connecticut, Utah, and Virginia. The tricky part is that there are 5 different state level privacy laws to comply with, so I'm really trying to thread a handful of needles. Have you looked into this multi-state privacy agreement from the Interactive Advertising Bureau? Yeah, of course. Have you? A little. It seems promising, an industry-wide framework that companies can use to standardize compliance with different privacy laws simultaneously. Yeah, it sounds good in theory, but I'm not so clear on how it works in practice. You're the technical expert. Can you explain it to me? It seems fairly straightforward from where I sit. How I understand it, the multi-state privacy agreement functions like a check-in form. Person visits a company's site, and the site jots down the person's state of residence or labels them a national consumer. National consumer is a whole thing unto itself, but it basically means that the company is going to treat the person as if they have to comply with all of the 5 state privacy laws. After jotting the person's state of residence, the company then checks off the different measures they need to take to comply with the respective privacy law or laws. For example, for a California resident, the company would need to notify the person that they have the option to opt out of the company selling their personal information, if the company sells their personal information under the law, and that they have the option to opt out of the company sharing their personal information, if the company shares their personal information for cross-contextual advertising purposes. Then the company needs to note whether the person did or did not opt out of their personal information being sold and or shared. If the company, you get it. There are also entries for sensitive data and child data, but let's move on. Once the checklist has been filled out, the company then decides whether it's operating in one of 2 modes, service provider mode or opt-out option mode. What's the difference between service provider mode and opt-out option mode? The big difference between the two is only opt-out option mode allows for data to be sold or shared for purposes like targeting ads or building third-party audience segments. Okay, and once the form's filled out, how does it get passed to other companies? After the mode is selected, the checklist gets converted into what's called a global privacy platform string that is then added to the calls made to various ad tech companies through the programmatic advertising pipeline. As the MSPA checklist gets passed through what's called the global privacy platform, it effectively triggers the creation of a contract between the company that originally collected the person's personal information and whatever companies access that information through the programmatic pipes. How does this trigger a contract to be created? Good question. Let me check with someone and I'll call you right back. All right, time for the real reporting. Is a hot dog a sandwich? Hello? Hey, quick question. I was watching your video on the US privacy compliance landscape in 2023, and you mentioned the multi-state privacy agreement. How does the MSPA trigger the creation of a contract? Yeah, that part seems pretty tricky. Let me check with someone who would know and get back to you. Hey, Michael. Thanks for taking the time to talk with me about MSPA.
Happy to speak with you.
How exactly does that work where MSPA can kind of consolidate all the contractual work that companies would need to be having in place where they're not having to sign 500, 1,000 different contracts with companies?
So, what we do with the MSPA through this network approach to creating a contract is when a publisher or advertiser who has who as the first party has the relationship with the consumer declares it to be a covered transaction, it causes the terms of the agreement to get triggered and go into effect with respect to the relationships that flow downstream. And so when that happens as it relates to the covered transaction, all of the necessary privacy terms come into place. So we've done all of the work.
Okay. I'm not a lawyer, obviously, but how is it that, an advertiser says, okay, these are, this is covered under MSPA? Like, what's the legality of that, or how is that then legally enforceable where that triggers a contract?
Sure. So think of this as a network of participants who are agreeing to be bound by the same contractual terms, and it is a springing contract. So let's break down what that means to be a springing
Please.
contract. In lawyers' parlance, right, there's some condition that has to happen in order for the terms of the contract to come into effect. So here we have a network already of 1,000 signatories who are saying, we agree to these terms when certain conditions are met. So that's what the springing contract does. It springs into place and follows the data throughout the distribution chain, which includes both the sell side and also the buy side.
Got it. But how does it like protect an advertiser from, some ad tech company becoming a signatory of the MSPA, but then not actually complying with it? Like, I'm trying to think of a case where advertiser shares data through the MSPA, but then they find out there was a bad actor signatory, and they try to take that bad actor to court, and the judge says, okay, that's cute that you all have this agreement in place, but why should this stand in my court?
Well, the MSPA creates a contract between the parties, and it means that it follows the data. And it does so between those parties who might already have contracts in place, but perhaps not the right contract in place under the applicable state laws. But also, there are disclosures of personal information that happen in the digital ad supply chain where there are presently no contracts that exist at all, but there need to be contracts going forward. And there will not be enough lawyer time in the world for all of those contracts to be signed and in place in the absence of something like the MSPA. And so the contract, as a springing contract, again, it creates essentially mini contracts that follow the data through the supply chain. So if somebody does something that's in breach of contract, you have the same ability as you would if you had your own separate contract with them to take them to court and get what a court would call an injunction to enjoin the bad behavior.
So that's what he said. Okay, so by signing on to use the MSPA, you're agreeing to be bound by the terms of the MSPA. And the regulators have signed off on this being compliant with the different privacy laws, because we're not trying to get into another situation like with GDPR in Europe and the IAB Europe's transparency and consent framework, and the Belgian regulators saying that that framework wasn't compliant with the GDPR in their eyes. Another good question. I'll call you right back. Whether or not a hot dog is considered a sandwich is a matter of personal opinion. Hello? Hey, one more. Do you know if regulators have said whether the multi-state privacy agreement is compliant with the different privacy laws? Yeah, I asked about that. What was it Michael said? And have the regulators said whether MSPA is compliant with the laws in their eyes?
Yeah, so this is a process that we're just beginning now because we just finished the MSPA in December 1st. We were still putting our final touches on, and now is the time we talk with the regulator. So one thing to sort of keep in mind about engaging with regulators in the United States, typically you don't go to a regulator and they say, okay, you've got the green seal of approval. We're good to go, and here's your letter showing this. And so, in the absence of that, it is typically about explaining to the regulator what you're doing and having them speak by their forbearance. So, I understand the desire for everyone to say, okay, this has a regulator, check the box, and that's clear. But the process is a little hazier than that.
So that's what he said. What the